came coming on like this super quick. Wasn't planning on doing this, and then I was like, you know what? I want to watch this, and so I was in here working at the computer, and I was like, I'll go ahead and just stream it real quick. So if anybody pops on, hello. Happy Monday. Happy Monday. Hey, P. Lola's mama. Hi, girlfriend. Hey. Hey, hey, baby. Thank you, sister. Uh, Thank you, Mickey Jor. Today's my birthday. Today's my birthday. Love you too, Mickey. Hey, Morgana Banana. I don't know what he's doing, P. Lola. He's in an ugly brown suit today. I don't know. He's in an ugly brown suit. Did y'all see him sitting there in his suit? Ugh. Gross. I bet he is eating a lot of casseroles from the old ladies, though. They're all like, "Hi, Harvey."
That's correct, Judge.
Is there anyone that is going to be attending on behalf of the state as well?
Yes, Your Honor. The Markel family will be appearing by Zoom, but they're relying on their statements previously made.
I can't hardly hear it. I got the volume all the way up, too, so. There he is. See, look at him in his ugly suit. And his jacket don't even match his pants. Lord have mercy. He got on navy blue pants and a brown jacket. No. No, 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 no. He looks very nervous. Right, Margaret. Hey, 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 Susan. Hey. Hello, hello. Thank you for the birthday wishes. Thank you. He's sitting there doing heavy breathing exercises. Yeah. Mm.
I won't read the phone number out loud, but his iPhone, one of the witnesses is about it.
I believe the gentleman appearing is our witness, Judge, in this case.
P. Lola probably. We can scroll it back afterwards and rewatch it again, but because she's been sitting there for a while and I've been sitting there watching, and she's doing the whole trembling and shaking thing for a long time. Now not so much, but she was sitting there all pretty in purple.
647 number belongs to Ms.
Lord, my hair is a disaster.
You can tell her to rejoin.
Lizzie.
Hey, Miss King. Hi.
Everyone on the Zoom can keep themselves on mute until it is time for you to speak, please. We're here this afternoon for final disposition and sentencing in case number 2023 CF 3226, State versus Donna Adelson. Parties can make their appearances.
Georgia Kappelman for the state.
Joshua's on for the defense.
Jackie Fulford on behalf of Mrs. Adelson.
Have the parties received their copies of the pre-sentence investigation report?
Yes, Your Honor.
Yes, Judge.
Are there any objections that either party wishes to make to the pre-sentence investigation report?
No, sir.
There are corrections that would need to be made, Judge.
What are the corrections?
Would you like me to stay in here at the link?
It's in there.
On page 1, they have the date of arrest as November 20th, 2023. And she was actually arrested on November the 13th of 2023.
I will notate. Ms. Kappelman, is there any
No,
challenge to those?
No, sir.
I will
Thank you for the
notate a
birthday
copy then that will be
wishes.
filed with the clerk as November 13th of 2023. Go ahead.
On page number 5, there are several. The first place, near the top, it says wage, salary, and this was supposed to be her current employment that she had, and it said $1,000. She did not have employment where she made $1,000. She was not receiving any salaried income, so that should be 0.
Ms. Kappelman, do you wish to be heard concerning those?
No, Your Honor.
So again, I will notate the wage salary as $0.00.
Thank you, Judge. The next, underneath there, it says the number of jobs in the past 2 years, 1. She has had no jobs. She's been employed the majority of the 2 years.
Which part of page 5 are you referring to?
Well, that's on page 5, right underneath the wage.
So no jobs, no employment.
Correct, that should be 0.
Ms. Kappelman, do you wish to be heard?
No, sir.
Notate that there has not been any employment or 0. Go ahead.
Thank you, Judge. Directly under there, it says months unemployed in the past 2 years, 0, and she's been unemployed for 2 years.
Well,
No
so
objection.
you're asking for that to be 24 months.
Correct.
Go ahead.
There are 2 typographical errors in the remarks section. The second line from the top in the remarks says history, comma, she. I believe that's supposed to say the.
Hey, Gail. Hi.
Give me one
Thank
moment. I'm
you.
finding it.
Thank you. Thank you.
You said history is the first word leading into the
History is
correction.
right next to the word she. You see that's on the second line down. It says remarks, and then the word right under there on my copy says history, comma, she.
Yes.
It should be the.
Ms. Kappelman.
No objection.
Go ahead.
And then in the same paragraph, 4 lines down to the far right, it said who had fallen in. That should be ill, I-L-L.
No objection, Judge.
Go ahead, Ms. Wolford.
Yes, sir. Going down under the financial status to where it says estimated total debts, in the second line, it says a second mortgage was taken out to pay for their home. That should say legal expenses, not home.
No objection.
Let's get through the boring stuff and get to the good stuff.
Go ahead, Ms. Wolford.
Yes, sir. The same section where it states remarks, 3 lines down, it says husband's dental practice. That's incorrect. The dental practice was not providing income prior to her arrest. She was only receiving Social Security assistance.
You're just asking husband's dental practice to be scratched through.
That's correct. The only income was, they listed Social Security, but they listed both.
No objection.
Well, anything else?
On page 7, Your Honor, about halfway down the page, it has the remarks section. And if you go 1, 2, 3 lines from the bottom where it's listing grandchildren, on the right, it has a child's name, 14, and then it says a female, 7. That's actually a male.
No, gotcha.
Right. Any other objections?
Not from the defense.
The court has reviewed the PSI report, and at this time I will direct the clerk to file it as a part of the record. Ms. Kappelman, do you have any other witnesses or evidence that you wish to present as a part of your presentation today?
I have some documentation regarding cost of prosecution, Judge. Would you like that at this time?
Yes.
The state has put together a summary page and a thumb drive. We are requesting $723,123.68 in restitution. Defense advised that they want
I charge your fan? I have no idea.
Request, which is contained on this thumb drive. They're just receiving it today. So have not had an opportunity to review it.
Honestly, I would not want to be a patient.
Cost of prosecution and reserve regarding the amount, and we'll see if we can reach an agreement regarding the amount.
Very well.
So that's one item that's in dispute for today. Another issue, Judge, is the score sheet. I've prepared 2 score sheets. May I approach again?
You may.
First includes death points, bringing the lowest permissible prison sentence in months to 172.5. The second does not include the death points, bringing the lowest permissible prison sentence in months to 82.5. Brought to my attention yesterday that the defense objects to the inclusion of the death points. The limited research that I've had an opportunity to do suggests that
Right.
they should be included if the death was a direct result
Same.
of the crime. I believe it was. The defense wants to argue otherwise, so whichever score sheet Your Honor chooses to go with, they're both provided there for you. The state is requesting, are you ready for me to argue what I want for sentence? Okay.
Go ahead.
Obviously, life on count 1, Judge, we would ask for 30 years consecutive to count 1 on count 2, and 30 years concurrent to count 2, but also consecutive to count 1 on count 3. I do not have any additional testimony or other evidence to provide, Your Honor.
I've had this issue of the death points being attached to the non-homicide offenses come up in other cases. Certainly the death points would attach if there were an offense that were being scored, but the first-degree murder is not being scored on the score sheet. What would be the basis, Ms. Kappelman?
That the death resulted from the conspiracy. It wasn't just a conspiracy without a death. It was a conspiracy that directly resulted in a death, hence the death points are appropriate.
What is the defense's argument concerning the score sheet?
I'll do my best, Your Honor, to know the weather for the last week or so. It's the same argument that was made on behalf of Dr. Adelson. Post-conviction, Your Honor granted the correction of the score sheet. Solicitation and conspiracy do not require an actual death. And I'll just rely on the same cases that were relied on by Dr. Adelson. State versus Johnson,
right?
561 Southern 2nd, 1321. The crime, quote from that case, the crime of solicitation is completed when the actor, with intent to do so, has enticed or encouraged another to commit a crime. The crime need not be completed. And then in Becky v. State, 423 Southern 2nd, 417.
That gives me the
Second
heebie-jeebies.
DCA, crime of conspiracy consists of 2 necessary elements: an agreement, 1, and 2, an intention to commit the offense. Once the intent is formed and the agreement is made, the conspiracy is complete. complete. Just like Your Honor did in
He's just jabbering right now, so I'm gonna
Charlie.
tell you guys real quick. After this is over, I want to talk to you guys and do a poll and find out what we want to do next. Because I don't know of any other trials that are really going on right now. So I wanted to make a poll and let you guys vote on what we want to watch this week. So don't go nowhere after the sentencing is over. Stay here because we're going to do a poll.
Certainly, if the state wishes to take any appeal concerning the score sheet, that
You
is
get
your
one
choice.
vote, Margaret. One vote.
Death points will not be added to the score sheet that is signed by the court. Is the defense ready to proceed with its presentation?
Yes, Judge.
You may proceed.
Thank you. Would you like me here or at the podium?
You may remain at the table, or you can come to the lectern, whichever.
Okay, thank you, Judge. I guess we would start with the witnesses that we have. The one who's standing by on Zoom is Dr. Ben Graber, who would like to make a statement on behalf of Mrs. Adelson.
Dr. Graber, if you at this time can please turn on your microphone. Please raise your right hand.
Husband will be home any second with my child from school, and today's our first day back to school since fall break. They were on fall break all week, so I'm gonna go see her when she pops in the door. So I'm gonna turn my camera off real quick, but I'll be listening.
Sir? Dr. Graber, if you can raise your right hand to be sworn. Do you swear or affirm the testimony you're going to provide today will be the truth? I believe you have a volume problem, Dr. Graber. I can see your lips moving, but I can't hear you. I guess just so I can test that we do have proper audio, Dr. Graber, before you get started, Mr. Markell, if you can turn on your microphone and say 1, 2, 3 for me so I can test this audio. All right, he's not coming through either. Time to troubleshoot.
Yes, but I didn't know what I was supposed to do.
Right. Dr. Graber, if you can say 1, 2, 3 while I test this equipment. All right, I can hear you now, but we can't get them over the loudspeaker. At least someone must have switched the audio settings. My mic's fine. It's the witnesses need to be heard. Right, thank you, Mr. Markell. I'm going to place you back on mute at this point. Right, Dr. Graber, try to talk for me one more time. 1, 2, 3.
1, 2, 3. 1,
There
2,
we go.
3.
Judge and a Radio Shack, man, all in one. All right.
It's working?
It is. Let me swear you in again, sir. Please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You can lower your head. If you're examining the witness, or is he reading a statement?
He's gonna present a statement, Judge.
Dr. Graber, you may proceed at this time.
Thank you, Your Honor. I appreciate the opportunity to come and speak on behalf of Donna Adelson. If I can, let me just brief description of who I am, my background. I've been a friend of the Adelson family since 1979. The first 20 years I knew them, we were actively engaged in many activities. The last 20 years, I haven't seen them that much until this trial became apparent to me. And my background is I'm a medical doctor practicing obstetrics and gynecology, 45 years here in Florida. I was also a state legislature from 1988 to 96, representing Coral Springs and parts of Broward County. I was a county commissioner in Broward County and mayor of Broward County for 1 year in 2006. Also a professor at the University of Florida Medical School and the University of Miami Medical School in clinical OB/GYN. And I'm here to speak today on behalf of Donna Adelson, this person I've known for a great deal of time. Hi Donna, just want to say hi. I'm sorry I can't be there to hug you. And I'm sorry we didn't get to have that dinner after your trial was over. But I'm here to, on your behalf, to let you know that you have friends, and I believe in you. Let me say that, Donna, I never thought we'd be here at this situation when I first met you. It was a total shock to me and to our families. And it's a tragedy for me to have to be here to talk about this. I feel very bad for your family, for the Markel family, for the tragedy everyone's experiencing. To me, I've been following this for 2 years. It appears to be a dissolution of two families. My background is similar in many ways to both families. Like Ruth Markel, I'm the son of Holocaust survivors. I actually was born in Germany as a displaced persons camp. Came to the United States at the age of 18 months. So like the boys, Lincoln and Benjamin, I don't have a lot of recollection from the first beginning of my time in the United States, but they don't have the recollection of their father, which is very sad to me. But they do have families, and I had family. And we have to learn a great deal from our tragedies as we come back into life. My distress is not just for Donna and the Adelsons, but for the Markels as well, and especially for 3 generations of each family, which I see in tragic downward swing. And yet, I did meet Lincoln and Benjamin at the bar mitzvah last year, and I got to meet those 2 boys, wonderful boys. Unfortunately, I never got to meet Dan Markel, but I have read many of his articles. Very impressive, very brilliant, very talented man who made some very good points about the law and about compassion in the law, which he felt could be improved. And I agree with that. So part of what I'd like to say today is basically that I do believe that Donna is a victim of not just circumstance, but has been actively exploited by parties involved in this case. I believe she was exploited by her son. Knowing Donna, who was the youngest child in her family, and knowing her mother, and how close she was with her mother, and understanding their love and need for family, it makes no sense to me that she would pursue an activity that would destroy 2 families like it has. However, having known her son and some of his issues, I believe Donna, in her own naive way, trying to be a loving mother, is subdued by guilt, by silence, by denial, and perhaps even active exploitation, and used for activities she had no part of. So I believe she's innocent on all 3 counts, even though she was found guilty on all 3 counts. Part of my understanding is also that the victims here are both families, and to watch the hate and distress and the vengeance I see is a terrible thing to look at. As Holocaust survivors, you'd think we would understand that better, how damaging it is to families. I would have to say, my background, I grew up in the Bronx, went to the public school system. I actually was at Queens College when Donna was there, but I didn't know her. She graduated a year after I did. My wife, Sandy, graduated from Queens College as well. When we got to Coral Springs, we met up after being there a while, new young families, professionals trying to build a life, having children, building a community, which we did. So to see this situation occur, to me, is devastating in many aspects. As a legislator, I can tell you that we see things in law. Even though I'm a doctor and I was chairman of healthcare, I was a Democrat, majority leader, I sat on the Judiciary Committee for 2 years, and understand the laws. Even wrote some of the sentencing guidelines and participated in passing them at that time. And what I learned over the years is that I had the privilege of passing many laws, because I was a leader and was able to work both sides. So many of my laws exist in the books. I get calls from judges periodically asking me about the intent of the law when I wrote it, because they have a case and it's come down to what did you intend to happen from this law. And they would ask my opinion, and they would use that information. So I'd like to look a little bit about the intent of the judicial guidelines for sentencing. I think the life without parole is a very harsh sentence. And that was not the intent, was to punish domestic cases with that, but to hit drug dealers and organized crime and dangers to the public. But I think it's been switched over to be used in conspiracy theories against the average citizen, which is not the intent of the law, in my opinion. Second of all, I think that it's unfortunate that this case has gone into so many new victims. And we've already, you have 4 victims who have been found guilty of murder. 2 have committed the murder, maybe 1. The others are conspiracy theories. And I would believe that I would suggest that needs to be reviewed by the legislature. That's my opinion. Now, in this case,
Dr. Graber, before you continue, is this being offered as character? Because he is not an expert on the law.
It's character, Judge.
Very well. You may continue, Doctor.
yes, that's my opinion from my background. It's not, I'm not giving a professional opinion. I'm giving my personal opinion from experience. What I'm asking the court today is, to me, the court, the judicial system, the power of the judicial system is in the judge. And it is the judge who is the presenter of a safety net for the public. To show some compassion when the cold written law, with every box checked off, shows no compassion, where does the compassion come from? It should come from the judge, it should come from the jury. And I think that maybe that's something we have to consider. So at this point, what I'm saying is that I believe Donna Adelson is a 5-star mother, did everything she could do for her kids, for her family, for her community. She has no bad intentions. She's not a leader, she's a baby in her family. She's always been the follower. Yes, she makes noise and she complains, but that's not her behavior. This is not her profile. So I understand that nothing can be changed, but I want to put on record that I believe she is innocent of these 3 counts, and we believe her. With that, I would have to say, sometimes bad things happen to good people, and I think this is one of those cases, and it's unfortunate. For the families, I would ask, beg them, think about the 2 boys. Dad is not here, but a piece of him is here, and those 2 boys. And their future, they're both teenagers now, their future depends a lot on what's going on here, and how they're going to be perceived in the future, and how they will interpret the future. based on this. So I think it's time for some compassion, some understanding, some forgiving. Perhaps it's time to take a step back and let everyone heal from this process. With that, I say to you, Donna, Daniel, I love you, we support you and the family, and we hope you the best. God bless you. And Your Honor, thank you for letting me speak.
Let's have an examination for the witness.
No, Judge.
Does the state have an examination for the witness?
No, sir.
Dr. Graber, you can remain on the Zoom. I would just ask you to mute yourself at this point.
Thank you.
Defense have any other witnesses to present or evidence?
Yes, Judge, we have Rick Chagrin, who's present, who would like to make a brief statement.
Please raise your right hand, sir. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You can lower your hand. You may direct the witness or you may give a statement.
If you could state your full name, please.
My name is Richard Gordon Chagrin.
And have you prepared a statement here today?
Yes, I have.
Okay, you can do that to the court at this time.
This is on behalf of myself and my wife Susan Brotman, an attorney at law. We have known Donna Adelson for over 35 years. She's been a dear friend and travel companion, and we are still in shock of her current circumstances. We know her to be a loving parent, wife, and grandparent. We stand behind her claim of innocence. We feel the trial was held in the county where there's been a lot of bad and inaccurate negative publicity, therefore not allowing a fair trial. We contend if a change of venue was granted, she would have been found not guilty. We are hopeful she will be relocated to South Florida, where she can pursue all legal remedies available. Thank you very much for your consideration.
Thank you, sir.
These are character statements or quibbling about the evidence and the rulings? Ms.
It's
Fulford.
character, Judge. They're here to talk about their friendship and time. Thank you.
Any witness examination for Mr. Chagrin?
Scott.
No, Your Honor.
You may be seated. Any other witnesses?
We did provide to the court, if you received your copy, Judge, some very short letters that were written as character support on behalf of Mrs. Adelson, if I may go through those at this time.
Go ahead.
Thank you. The first letter that was submitted to the court was by Annie Cunningham and Ronald Gutterson, who testified at trial. They say, "We are writing this letter to restate our knowledge and feelings regarding Donna Adelson. We have known Donna since 2009 and consider her to be our dearest friend. Donna is a kind, caring, loving person. She was always concerned with the welfare of others. She is not the monster portrayed by the media. Donna is incapable of threatening or harming anyone. Donna is almost 76 years old and in frail health after almost 2 years of incarceration. We will always believe her to be innocent and ask the court to take these factors into consideration when deciding Donna's sentence." Next, we submitted to the court was one of her longtime friends, Ruth Rosenberg, who wrote, "I immigrated to the USA from Israel when I was 1 month shy of 12. I lived in Israel in a town of 5,000 inhabitants where my family knew almost everyone and came to New York City, Queens, with a population of close to 8 million residents. To say it was a culture shock is an understatement. I didn't speak any English and physically looked like an underdeveloped child in comparison to the American girls my age. I entered the 7th grade in September, not knowing any English, the, quote, stranger in school. For several months, I sat by myself at lunchtime in the cafeteria, staring at the next table, where Donna and a group of her friends were conversing, laughing, and having a nice time. One day, Donna walked over to my table and asked me if I would like to join them, and of course I said yes, please. That kind gesture started a 62-plus year friendship. She invited me to her house to meet her family, and over time we became like sisters. I can recall several instances where Donna helped me obtain a job so I can help my parents financially. She introduced me to a family in a bungalow colony in the Catskills who needed a mother's helper for their daughters in the summer of '66. The money I earned helped my parents pay for the closing costs on their house. The following summer, she got me a job as a counselor at Camp Allegra in the Berkshires. When I had to decide on a career path, I consulted with Harvey and Donna about applying to dental school as my college advisor had recommended. Later that year, I was chosen to be the maid of honor at their wedding. We remained close friends throughout the years, even though we lived more than 1,000 miles apart. Our families visited each other periodically, making sure that our children and grandchildren got to know each other. We attended life cycle events of our children, bat and bar mitzvahs, weddings, special birthdays, etc., and now our grandchildren's. Donna has always been a kind-hearted, generous, loving, and caring. She is one of my best friends, and I will forever remember and appreciate how she helped me with English while I helped her with math in Parsons Junior High School, and remained loyal through these 62-plus years. The situation she is in today is unimaginable to me. That is not the person I know and love. We also submitted a letter from Ron Ellis to the court. My name is Ron Ellis, and I have had the privilege of knowing Donna Adelson for more than 30 years. I am writing to you in hope of offering some perspective on the woman I have come to know so well over the course of our long friendship. Donna has been a steady and caring presence in my life. When my stepson passed away 11 years ago at the age of 34, Donna was there for me in ways I will never forget. She sat with me in my grief, listened when I needed to talk, and offered comfort when I felt overwhelmed. That kindness and empathy is the Donna I know. Someone who shows up for her friends and offers strength in their darkest moments. Over the years, I have seen Donna's compassion extend beyond just me. She has been a devoted mother, a loyal friend, and someone who consistently tried to bring warmth and generosity to those around her. I understand fully the gravity of the situation before the court, but I hope that when you consider Donna's sentence, you will also weigh the years of kindness, care, and humanity she has shown to others. I believe that Donna still has the ability to contribute positively, even under these circumstances, and that she is capable of reflection and growth. I respectfully ask that you take these qualities into account when you make your decision. Thank you for your time and consideration. Respectfully, Ron Ellis. And then a brief letter from Marion and Tim Schaffman. She writes, we have known Donna for over 50 years, and although we live far apart and have seen her often over the years, we wanted to share with you our impressions of the lovely person we have known. Donna has always been a loving, kind mother and wife, and also an exemplary daughter to her parents, who often stayed with their family. We have never heard her utter a negative word about anyone, and had tremendous pride in every member of her family. She retained many friends from her childhood and developed long, satisfying friendships with the new people she met throughout each stage of her life. Donna was always intelligent, charismatic, and sensitive to everyone. She always listened to anyone's problems and offered a helping hand when she could. Most notably, her genuine concern over our and others' health issues was truly appreciated. As you can see, it is very difficult for us to view her as anybody other than the sweet, caring person we knew. Sincerely, Marianne and Ted Schaffman. Next is a letter from Jessica Usury. Dear Judge Everett, my name is Jessica Usury, and I am writing this letter to express my personal experiences and knowledge of Donna Adelson's character. Donna and I share a beloved grandson, Roman Harvey Adelson, born in 2017. My first memory of Donna is a video made and shared on Mother's Day 2017. Charlie Adelson surprised his mom with the news that he and my daughter Brianna were expecting a baby. It warmed my heart to watch Donna's genuine excitement and happiness caught on video. Our families began spending time together as events and celebrations took place. I recall Donna being warm and welcoming. As I got to know her more, there was no doubt in my mind that she was a loving and devoted wife, mother, and grandmother. Roman's birth was a scheduled cesarean section on December the 5th. On that day, I was overcome with mixed emotions of excitement and fear. A family awaited Roman's birth at the hospital during unnerving procedure. Donna was affectionate and compassionate, as I was visibly anxious and emotional. I will always remember how she reassured and calmed me that day. We shared tears of joy and the hugs when a beautiful and healthy boy came into this world. Donna was caring and supportive of Bree as a new mom. I have many fond memories of time spent with the Adelsons. Although Charlie and Bree were no longer a couple beyond Roman's first year, we all remain close. Donna has been kind, thoughtful, loving, and generous. Thank you sincerely for taking the time to read the letter, Jessica Goosery. And then a short letter to whom it may concern. I've worked at Adelson Institute for Aesthetic and Implant Dentistry from October 3rd, 2011 to September of 2022. During my time of working there, I had the opportunity to experience the beautiful person that Donna Adelson is. Through my time of working often side by side with her, I've witnessed her grace and ability to diffuse upset patients. She is incredible with having compassion for others and is truly one of the sweetest people I know. She's so supportive and understanding when it comes to her employees. When an elderly person comes in as a patient, she always made sure they had assistance, whether needing help filling out forms or even opening the reception door for them. She always jumped at the opportunity to be kind and helpful. I witnessed this and I know it was sincere. I still use what I've learned from her and apply it while I'm at work every day. I recognize the gravity of the situation and understand the seriousness of the legal process, but I respectfully ask that you consider the positive qualities that define her. Sincerely, Erica Johnson. And then the last letter that we submitted from was Attorney Gary Cohn. He said, my name is Gary Cohen. I've been a member in good standing at the Florida Bar since 1980. I have known Donna and Harvey Adelson as personal friends and personal counsel for almost 40 years. Harvey was also my dentist for most of those years. I have been in the Adelson house, and they have been in mine numerous times over the years since their children were little ones. My wife and I have socialized with Harvey and Donna at dinners, blessed events such as bar and bat mitzvahs, and weddings, birthdays, and many other occasions. I've also traveled with them, including a wonderful trip to Africa with 2 of my sons several years ago. I therefore have had a unique opportunity to observe Donna under many circumstances. In all the time I have known her, I have literally never heard Donna raise her voice, lose her temper, act inappropriately, or treat anyone with less than full respect, and almost always with a smile on her face. I have never heard a bad word said about Donna from any other friend or person in my presence. She has always been an amazing mother to her children, and she and Harvey have had the most loving marriage that can be imagined. While I cannot comment on any of the facts of this case or any of the alleged events, I can say that the Donna I know is the last person I would ever think of when it comes to what has been this utterly horrible crime, dealing with the death of Dan Markell. Being a trial lawyer for 45 years, I fully believe in the jury system and understand that a jury has spoken. However, the woman I've known so well for so long also needs to be understood as the wonderful wife, mother, grandmother, and friend that she has been known to me. I only hope that this information can be of use to the court when it comes to the sentencing of Donna Adelson. Gary Cohen. At this time, I believe that Mrs. Adelson's husband, Harvey Adelson, would like to address the court.
Very well. Do you wish to enter these letters into evidence?
Yes, Judge.
Does the state have any objections?
No, Your Honor.
They will be composite defense 1 for sentencing.
Thank you, Judge.
Dr. Adelson, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, I do.
You can lower your hand. You may speak.
Thank you, Judge, and respected officers of the court for allowing me to speak. I have been Donna Adelson's husband for over 50 years. My wife sacrificed everything so that she could pour her heart and soul into our children, our grandchildren, and our marriage. This summer was our 54th wedding anniversary, and I had to spend it without her, hand in mind. She has done nothing wrong, and yet is being punished for a crime that she did not commit. I thought we lived in a different kind of world, but I guess I was wrong. I have listened, watched, and sat in the courtroom for the entire trial, and I could not help but scream in my mind by the witnesses that were brought forward by the prosecution who told outright lies. I didn't know that you could lie in a courtroom, but apparently you can. Danny's parents contend that they have never seen their grandchild. But for years they say they've never seen her. But Wendy has shared with me pictures and videos and letters from their visits. They have suffered immensely at the loss of their son, but they also contend to tell lies to the court about our grandchildren. Donna has always been a loving and caring wife and is innocent of the charges. A biased judge and jury were influenced by years of one-sided news pieces and
Before you
social
continue,
media.
Doctor, Ms. Fulford, this has nothing to do with the character of the defendant or relates to sentencing.
May I just one moment, please?
Go ahead.
Thank you.
I couldn't understand what he said to Charles. What did he just say to Harvey? I mean, what did he say to him? The judge interrupted his anger flow, though, didn't he? I didn't know people could lie in a courtroom. Right. Sorry, kiddo, come flying in here. I know, Margaret. Everybody else is the liar, right?
Just one second, please.
Didn't they take care of all this beforehand?
All right, thank you for letting me continue. Donna did not participate in the heinous acts that she was convicted of doing. You are sending an innocent woman to prison. You have taken my wife, and you have taken my life as well. And for what? This is not justice. It is vengeance, and it is wrong.
You have an examination for Dr. Adelson.
No, Your Honor. No, Judge.
Any other witness statements that you wish to give?
I don't believe so, just one second.
That's what I figured, Gail, but I can't hear him. The audio in there is horrible.
We don't have any further witnesses, Judge, but Mrs. Adelson has decided she would like to make an unsworn statement to the court.
Unsworn?
Yes, Judge.
All of the witnesses will be sworn this afternoon if she wishes to speak.
Ooh, Donna wants to
Case
speak.
law indicates, confirms that the defendant has the right to make an unsworn statement prior to sentencing. The court, Rule 3.720B states the court shall entertain submissions or evidence by the parties that are relevant to the sentence. A number of cases, Your Honor, that have interpreted this, especially in a capital case, as the defendant having a right to make an unsworn statement. This is a capital.
Please give the citations.
Yes, Your Honor.
What in the world, Gail, is going on? I thought you
First
got all
is
that
Smith
fixed.
versus State, 268 Southern 3rd, 831. It's from the first DCA in 2019. You want me to continue, Your Honor?
Give me one moment.
Yes, sir.
Bringing up my Westlaw. Give the citation again.
Sure. It's 268 Southern 3rd, 831.
Which pinpoint site are you referring to in the case?
It's about, let's see.
Oh, good grief,
Your Honor,
Gail.
I'll give you this one. It's Hill versus State, 246, Southern 3rd, 392.
I'm sorry, that sucks.
For the 4th District Court of Appeal?
One moment.
Yes, sir.
246 on the third, what's the last part?
392.
Well, seeing in the case where it does state the defendant has a right to make an unsworn statement, we will proceed.
Thank you, Your Honor.
Would you like Mrs. Adelson at the lectern or here?
She can remain at council table.
Thank you, I'm gonna move the microphone. I think you speak loudly because this is not amplified.
Okay. Is this loud enough, Judge?
I can hear you.
Thank you for letting me speak. My son-in-law, Dan Markell, was a fine and decent man. He was well-educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18th, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them, and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." But pictures and memories are all they have, because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without the father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is what they call the, quote, mastermind behind this murder. In both of Catherine Magbanaw's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case. Where is the evidence before July 18th, 2014 at 10:50 in the morning?
Before you continue,
That
Mrs.
revealed-
Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
No, Judge, just giving Mrs. Adelson an opportunity to be heard.
Mrs. Adelson, you certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had
Wow.
any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show
The
that there
lack
was
of
evidence
remorse.
before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop, to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media, printed news, television news, and podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, "I believe she is guilty." Not one person, not one, said, "I think she may be innocent." That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror,
Mrs. Fulford,
oh, I didn't hear you.
Mr. Zellman, again, this has nothing to do with elocution of any sort. This is a raising of grievances which are properly given to the appellate court. What does any of this have to do with sentencing?
Brad, just one moment, please.
This is hilarious. The judge is like, did you see the officer look at him whenever he asked the question? The officer looked at him like,
Turn that phone off or step out.
oh, he is not having it, buddy. Not today. Give up, Donna.
When the phone is off. Please.
What happened to Danny is unforgivable. But I am an innocent woman convicted of this terrible crime without evidence. Danny was a brilliant legal scholar. He would have been appalled at the total lack of justice that went on during my trial. He would have been embarrassed to have his name associated with any of it. There are two crimes here. The first was Danny being viciously murdered. The second one is taking my life, the life of an innocent woman. Convicting me should not be retribution for Danny's death. That is not justice for Dan. I've always respected the law. I've never gotten a parking ticket, but I'm going to prison for a murder I did not commit. I do intend to file an appeal so that hopefully I have the opportunity to be given a fair trial outside of Tallahassee. 11 years ago, Danny was murdered and taken from all of us who loved him. For the past 9.5 years, the state has broadcast to the world, including Danny's parents and sister, that I hired hitmen to kill him. Never in a million years would I have wanted Danny to be harmed or killed, nor could I ever do something that would leave these two small boys to grow up without him. I love these boys more than life itself. This is a lifetime of loss for these children. They didn't deserve this. His family didn't deserve this. Danny didn't deserve this. And so, as I appear before you today, Your Honor, I promise you with my whole heart, I swear to you on my life, I was not involved in any way with Danny's murder. I was not.
Defense have any further argument to make?
Yes, Judge.
Judge, before Ms. Fulford makes the argument, I want to address a comment that the court made a few moments ago concerning considering lack of remorse in fashioning a sentence. Ship of Restate 227 Southern 3rd, 746, the First District Court of Appeal held that lack of remorse cannot be considered in fashioning an appropriate sentence. If this were a situation where remorse and admission of guilt may be grounds for mitigation, the lack of these factors cannot be used to increase the defendant's sentence, and such reliance violates the defendant's due process rights. And they also rely on Ritter v. State 885 Southern 2nd 413, also a first DCA case.
I believe the Supreme Court has ruled on this issue concerning remorse and lack of showing remorse.
There you go, Margaret. There's Charlie Brown's teacher.
Well, if you need me to find the citation for you, I will.
Yes, please.
We'll take a 10-minute break.
She is insanity, man. Insane. She's insane. That's all there is to it. Hi, Rosa. Welcome.
We'll resume at 4:16.
Right, Charger. Allocution is all about remorse and pleading for leniency. She just basically insulted the judge by telling him that he allowed for a unfair trial. One that Dan would have been embarrassed to have his name attached to. I mean, really? The audacity. Yikes. Yikes, man. Her shaking and trembling, I don't believe is even real. I think she's fake all the way around. Everything about her. Everything about her. We're like 30 seconds behind, so now it's live. I'm caught up live. We were like 30 seconds behind. I don't know. Do you think that the judge is going to just give her her sentence and be done, or do you think he's going to read her the riot act? Because you never know. I always love when the judges do that, but some judges don't do that. And I want to know. What do y'all think? Do y'all think he's going to read her the riot act? Or just give her her sentence and be done? Egregious. My brain is saying so many words right now, and they're not nice ones, says Cherie. Right? I know. I know how you feel. I know how you feel. I just don't know. I don't know. I know he's going to throw multiple books at her. That's what I know. You think she will, Gail? I understand why they don't, but I love when they do. Because I'm going to give them a piece of my mind. You know what I mean? Hi, Lindsay. Lindsay says, hi, I'm new here. Wish the judge would have stopped these people, including Donna, for their improper use of time and further causing of trauma. Well, I mean, when she started reading her whatever that was, instantly I thought, oh, God. There's no part of her, though. There's no part of her that is going to be like, I'm so sorry for my part. I mean, she's not going to admit to anything, right? No. She's not going to admit to anything. No. In her mind, she's just the sweet little Donna that everybody got up there and said about her. How she was so sweet and caring and such a good wife and mom. Okay. Do you think he's over it? I think he's over it too. But I do think, I don't know. There's like, give us some, I can't think off the top of my head, some instances where the judge like just completely obliterated them during their sentencing. And then another instance, or an instance that I can think of where the judge just was like, okay, I'm done. It was like Sarah Boone, right? I was waiting for him to just give her the what for, and he didn't. And people were saying in the chat, I remember they were like, he's not going to give her any ounce of anything because that's what she wants. You know what I mean? She wants to be acknowledged, and he's like, you're not important enough for that. My family, I'm telling you what, I think people are popping in here, so I turned the camera off, and I think it was my dog. I think it was my, oh no, hold on. Husband is running back to town to get some stuff, and so that was him coming in here telling me he's going. The Sarah Boone book was amazing. She would have twisted anything. There's a book? Lindsay, there's a book? What book? I'm out of the loop on that kind of stuff. I'm out of the loop. Oh, gotcha. Throwing the book at her. I see what you mean. Yeah. I don't know. So, one thing I was going to ask you guys, I'm going to put a poll up really quick while we're waiting. They may come back before I get the poll up, though. Hold on. I have to open this on YouTube. View on YouTube. Let me do this real quick because it won't let me do it from StreamYard. I have to do the poll on actual YouTube. So give me a second to let this pop up on my computer. Lindsay, honey, squirrel mode is on every day here. True story. And thank you for joining, new folks that have popped in today. Thanks for coming and hanging out. I was out all week last week. Last week was fall break for the kiddos. They were out of school for the week, and then they went back today. So, yay for that. Margaret, you get to vote once, ma'am. Margaret, one time. You get to vote. One time. One time only. Okay. Let me get it. Okay, here we go. Let me find. Okay, start a poll. All right, let me get my keyboard up here. And I will type the questions. Hold on, let me turn my camera off because I can't stand whenever get back in school, kids, too soon. Well, I was talking to somebody yesterday and they were like, my kids don't go on fall break till like close to Thanksgiving. Ours always has it this early. They always have it this early, but then they get like 2 weeks off at Christmas. They get off like right before Christmas and then through right after the first of the year. So, I don't know. Okay, hold on. Let me get this poll up. Hold on, I'll be right back, guys. Oh, they're back. They're back. They're back.
Review Davis.
Briefly, Your Honor, Davis was not a capital case. This is a capital case. Although the criminal punishment code would only apply to the non-capital cases, I would argue submit to Your Honor that it is distinguishable under those circumstances.
Going to read from Head Note 8 and 9. Nor was Davis forced to choose between allocution and maintenance of his innocence. He certainly could have allocated without voicing his disagreement with the verdict, blaming the driver, the police, his lawyer, the trial court for his conviction, and attempting to explain his personal interpretations of the law to the judge. He could have asked for leniency without admitting guilt. He could have provided the judge with reasons to impose a sentence less than the maximum besides his claimed innocence. But he instead chose to make a lengthy statement claiming innocence, denying responsibility, and placing blame for his conviction on the alleged misconduct of others. The trial court was under no obligation to ignore such statements and did not err in considering those statements and imposing the legal sentence here. Do you have anything that distinguishes Davis in any way?
As I said, Your Honor, Davis was not a capital case.
Well, any other argument or evidence the defense wishes to present?
Yes, Judge, thank you.
Please move forward.
Your Honor, we're aware that in count one, the court has no choice but to sentence Mrs. Adelson to life for the first-degree murder charge. We are going to request a downward departure as to counts 2 and counts 3, the solicitation and the conspiracy counts.
What are the grounds?
Pardon me?
What are the grounds?
Yes. The grounds are, one is non-statutory, and that's disparity in the treatment between co-defendants. And the second reason is statutory, and it is Florida Statute 921.00262B. The defendant was an accomplice to the offense and was a relatively minor participant in the criminal conduct.
The evidence in support of sub B would be the trial record, or do you have something more specific?
For 4B, we're going to rely on the trial record with respect to the conduct of Mrs. Adelson, and we would ask the court to take judicial notice. Your Honor did preside over Charlie Adelson's trial, and the evidence regarding the other co-defendants' activities or participation was also brought out in the testimony in the trial of Mrs. Adelson, so we'd rely on that record, Judge.
Ms. Kappelman, as to the argued grounds for statutory mitigation and also non-statutory mitigation, does the state have any argument to make?
No, Your Honor.
You may continue.
Thank you, Judge. I'll start with the disparity. Do you need case law citations for this, or you're aware of it, Judge? Okay. The first case would be Sanders v. State, 510 Southern 2nd, 296. This is a Florida Supreme Court case from 1987.
One moment, 510 Southern Second, what was the other part of the citation?
I have copies, Your Honor.
296, and that's Florida Supreme Court in 1987.
Go ahead.
State versus Fernandez, 927 Southern 2nd, 939, which is a third DCA case from 2006.
May I approach, Your Honor?
You may.
And then the third case, Judge, is State, I can't pronounce it, but State versus Kunkemoller, 333 Southern 3rd, 335. That's a first DCA case from 2022, but it is distinguishable because it does not address the issue of culpability as the first two cases do.
Ooh,
And I
we
wanted
almost
to
had
bring
good
that to your
audio for
attention.
a second, and then they turned it back off. Come on. I'm so impatient. I'm gonna go fix a cup of coffee. I'll be right back.
You may continue.
Thank you, Judge. I'll start with the disparity argument, if I may, Your Honor. In this case, there have been several co-defendants who have either been tried or entered pleas and received sentences. I want to, for this particular argument, relate exclusively to Luis Rivera. He testified in the trial, and through himself and other witnesses, Your Honor has heard what he did in this case. And what he did in this case compared to what the state has alleged and the jury found that Mrs. Adelson did, the culpability levels are very different. Mr. Rivera was allowed to enter a plea to second-degree murder. And although, as the PSI indicates, he received a sentence of 19 years in the Department of Corrections, that was run concurrent with a sentence he was already serving in a completely unrelated matter in a federal case where he got a 12-year sentence. So the number of years that he will actually serve for his participation in the homicide of Dan Markell is 7 years in the state of Florida Department of Corrections. His conduct, as Your Honor can recall, is that he traveled to Tallahassee sometime in June and scoped out the home of Danny Markell, engaged in some drug activity with Sigfredo Garcia, and then returned to South Florida. A few weeks later, he returned to Tallahassee and again scoped out Danny Markell's house. But he didn't just do that. Prior to arriving in Tallahassee, with himself knowing that he and Sigfredo Garcia were going to kill Danny Markell, he purchased and provided the very firearm that was used to kill Danny. He came to Tallahassee and they sat in wait outside his home. They followed him with Mr. Rivera being the driver, followed him while he took his 2 little boys to daycare, and he sat and watched as Mr. Markell, hand in hand, took those children inside the daycare. He then followed Mr. Markell all the way to the gym, sitting in wait. What was he waiting for? He knew what he was waiting for. Mr. Markell did not. He had no clue that these men were outside in a car just waiting for him to go to a place where they could shoot and kill him. And they waited until he exercised. They watched him get back into his vehicle, and then, like hunters, traveled and followed all of this time period straight to his home. And there was no hesitation. He knew exactly what they were going to do. Without any hesitation, they pulled right in behind Danny. Danny's car was still running, the garage door was up, and Sigfredo Garcia exits the car and shoots Danny Markell, having done nothing to these men, in the head twice. How Mr. Markell survived, I don't know. But then Luis Rivera is the getaway driver. They flee the scene, they flee Tallahassee, and then Mr. Rivera stops to allow Sigfredo Garcia to dispose of the murder weapon, which has never been found. And then he drives back to South Florida like nothing has happened, purchasing motorcycles and cars, but most importantly, getting paid for the work that he's just done. The payment came from Catherine Mangbanawa, and I'll address her in the next segment. The point here is, Judge, that over time, reading different things, you've heard a lot of arguments about what Mrs. Adelson's participation allegedly was. But when it comes down to it, and I didn't mention, but Luis Rivera did have an extensive criminal history at the time that he committed this offense. What actually came out at trial with respect to Mrs. Adelson, and I'm saying this, understanding, as you've learned, that Mrs. Adelson still maintains that she is innocent of this conduct. But what the state was able to show through their testimony and evidence was that the role that she played, according to them in the prosecution, was very minimal. The evidence showed that she was very upset when relocation was denied in 2013, not knowing that her daughter had agreed to it, not knowing that until she sat here in trial hearing her daughter's testimony. She wrote some very ugly emails. She said some very ugly things. But in not one of those emails did it ever say that she wished harm upon Danny Markell. And this was in 2013. The evidence was presented by the state that was over a year later that Danny was killed after relocation had been denied. Although they argued that there was continued hostility on the part of Mrs. Adelson regarding the issue of relocation, with the hundreds of thousands of emails they had, they didn't present evidence that this ongoing dispute was being brought up in any way between the parties. The relocation between them, that issue had stopped. The testimony that was elicited was that Charlie Adelson, the son of Mrs. Adelson, was the one who was close with Mrs. Adelson, and that when she had a problem, the argument from the state was, when she had a problem, Charlie was the problem solver. And the testimony at court that was presented by the state supported that theory, that Charlie was the problem solver. They further elicited evidence, testimony, that without any knowledge of what the phone calls were, Catherine Magbanawala testified that when she was with Charlie Adelson discussing scenarios, which she didn't describe what scenarios she was discussing, that on occasion there would be a phone call between Charlie and his mother. She didn't hear the mother speaking. In fact, he left the room when he talked to, allegedly, the mother, and he came back in. He never relayed to her any information about the phone call. But the state's theory and the evidence that they presented was because Donna Adelson had been so upset about the fact that relocation was denied, and she continued to be upset, according to the testimony, that Charlie Adelson took it upon himself to reach out to someone, which was his girlfriend, and have her get someone that she knew who could commit this murder, make contact with them. According to the testimony in the state, in this case, Charlie Adelson told Catherine Magbanawala, I'm not trying to be disrespectful, it's just as the names were reused, but Mrs. Magbanawala, that she wanted him killed and he would pay for that to happen. Her testimony was she had no idea what the payment was going to be, but she did in fact reach out to the father of her children, Sigfredo Garcia, and he agreed to commit the homicide. Mr. Garcia then elicited Luis Rivera to participate with him in the homicide, and I'm not going to go through all the evidence in the case. I want to focus on what Mrs. Adelson allegedly did. Up until the point of the homicide, the only evidence that was presented about Mrs. Adelson's participation were those ugly emails. And there's a distinction, as we discussed during the trial and sometimes even at sidebar, of the evidence being up to the moment that Mr. Markel was killed. Up to that time, the only evidence introduced by the state in this trial for that time period were those ugly emails, and they were ugly. She called him very foul names. She said some ugly language. She clearly was not happy. And whatever conversations may have taken place while Catherine Magbanawala was inside Charlie Adelson's home and Charlie was outside talking to another person. Mrs. Adelson maintains her innocence. But if you're looking at this particular cause of this disparity in treatment, the state is asking that Mrs. Adelson be sentenced to obviously life on count 1 as she has to be, followed by 30 years in the Department of Corrections on counts 2 and 3. This is far in excess of the sentence that was received by the man who himself testified to hunting down Danny Markel, providing the gun for him to be murdered with, leaving the scene of the crime, disposing of the murder weapon, and going on with his life in his gang as he always had. In that disparity, Judge, it just doesn't reconcile with the facts here of what they say Mrs. Adelson did. Although there was a theme that she was the mastermind, I would argue to the court that the evidence did not show she was the mastermind in any way. The masterminds that were shown in this trial were Charles Adelson and Catherine Magbanawala. It didn't show any activity prior to Mr. Markel being killed where Mrs. Adelson was involved in any way.
Take away what you're arguing as the theme for the moment. The chief difference between Luis Rivera and your client is he entered into a plea, correct?
That's correct. He did enter into a plea, but that, according to the case law, that can be considered.
And he has also cooperated with the state testifying in many trials.
He was a cooperating witness testifying in these trials. Mrs. Adelson not only has maintained her innocence, she was never offered anything from the state.
Please continue.
On the statutory basis, that the defendant was an accomplice to the offense and was a relatively minor participant in the criminal conduct. Some of what I've just argued applies to this one as well, Your Honor. But what I wanted to point out here were the ones that we didn't discuss. So Sigfredo Garcia was found guilty at trial, first-degree murder and conspiracy. His sentence was life on the homicide and an additional 30 years consecutive for the conspiracy count. He is the one who rode in the car. He is the one who obtained Luis Garcia to go with him. He is the one who sat in the seat knowing he was going to exit the car while they hunted down Danny Markel. And he's the one who got out and shot Danny Markel in cold blood. Left like nothing had ever happened. Along the way, made many stops, including getting out to hide the murder weapon, and then went on with his life. The killer is getting the same sentence that the lesser participant, the state is suggesting, get as well. Life in prison on count 1, followed by 30 years for the conspiracy and solicitation. Luis Rivera, I've already told you what his role was. Catherine Magbanawah got the information from Charlie Adelson according to the evidence, and at his request obtained someone, Sigfredo Garcia, to do the killing. She is the one who coordinated between Charlie Adelson and Sigfredo Garcia and Luis Rivera, although she testified that she didn't know Luis Rivera was involved until after it was over. The evidence that the state submitted clearly contradicts that. She was communicating with Luis Rivera before, closely to the homicide, and then shortly thereafter. She's the one that spoke to him. She was sentenced on the first-degree murder to life in prison, and on the solicitation and conspiracy, she was sentenced to an additional 30 years. It was run consecutive. Again, the same sentence that they're asking for on Mrs. Adelson is the sentence that this woman who heard the request for a homicide, found the person to commit the homicide, stayed in communication with both of the individuals who are responsible for killing Danny Markel, followed up with them and provided payment to them, and then took payment back from them for her to keep for herself. She was also paid in this. She participated, knew it was happening. They had proof that she knew it was happening. That was submitted to the court. All of that evidence clearly distinguishable from the conduct that they presented in evidence about what Donna Adelson did. Charlie Adelson, according to the testimony in this trial and his own, Charlie Adelson wanted Danny Markel dead. So on his close or very first date with Catherine Magbanawah, he asks her out in public at Halloween, some Halloween function, hey, do you know anybody who could get somebody killed? According to her testimony, she followed through with that. With Charlie Adelson, never with Donna Adelson, never communicated with her in any way about this. She worked then, if that's what happened and that's what's been testified to, she worked with Charlie Adelson from October of 2013 until Danny Markel was brutally killed in July of 2014. That entire period, and there's evidence, she admitted to most of it, to her conduct, and there's evidence that was presented in this trial and Charlie's that that's what happened. They made this plan, and that his stapled money was used to pay the killers in this case some $130,000 in cash that was divided up amongst Sigfredo Garcia. Sorry, my mouth is getting dry. Excuse me.
Go ahead.
Thank you, Judge. It was divided up between Sigfredo Garcia, Catherine Magbanawah, and Luis Rivera. She then stayed in contact with Charlie Adelson. She convinced Charlie Adelson to get paychecks written to her, and she received those paychecks each time from Charlie Adelson. So for what Catherine Magbanawah did and what Charlie Adelson did, the evidence in this case shows it went far beyond what the state's evidence showed that Donna did, up to and including the time that Danny was killed. So again, if you're going to rate the level of culpability in this case and consider Mrs. Adelson's conduct as compared to those, They're asking that she get the same sentence as both of the people who killed, well, one person that did the killing, Sigfredo, a far more extensive sentence than Luis Rivera, who participated in the killing himself and only got 7 years. The same as Catherine Magbanawa, that apparently worked on this, according to the evidence, for many, many months and stayed involved even after that. Charlie Adelson is the only one who got a higher sentence. His sentence was life on count 1, the homicide, followed by 30 years on count 2 and another 30 years on count 3, so everything being run consecutively. The evidence that the state has presented is that Charlie Adelson is the one who masterminded this. That's what they've shown. Even though they said Catherine Magbanawa wasn't her trial, if there's somebody who started this, according to the evidence, it's Charlie Adelson, not Donna Adelson. All the work being done was Charlie Adelson. All the money that was paid was Charlie Adelson's money. Mrs. Adelson, according to the state's evidence, did not do any of that. Again, they had hundreds of thousands of dollars, or hundreds of thousands of emails. Never one in all of those emails that we all had to go through did Mrs. Adelson ever suggest any harm to Danny Markell in any way. I understand the verdict, and she has a right to take an appeal, and that's what she'll do. But the evidence in what was argued is very far different in theory than what was actually presented to this jury. And I'm requesting that Your Honor, in determining a sentence on counts 2 and 3, take into consideration that the amount of activity that everyone engaged in this case was far, far beyond what was alleged against Mrs. Adelson. They just didn't come up with the proof for that. They did prove to a jury that she was involved, but that proof and the actual evidence was very limited to the conduct that they say that she engaged in that resulted in Mr. Markell's death.
Queen baby.
I do want to remark, if I may, just briefly on the issue of remorse. Mrs. Adelson maintains her innocence, and as she has a lawful right to do, will seek an appeal. She may not get another trial. There may or may not be parts of the finding of the jury that is reversed, may not. They can do that on, the appellate court can do that on 1, 2, or 3 counts. There are lots of options that the appellate court has. The reason I say that is this. Mrs. Adelson, maintaining her innocence, could not have shown more remorse for the killing of Danny Markell. And in her statement, although some of it I know was bothersome to the court, in her statement, I hope you heard.
I wouldn't say bothersome to the court.
Okay.
Please continue.
Okay. I misread then. I apologize based on your comments. One of the things she said in her statement, after most of her statement being about the horrible thing that happened to Danny Markell, was that the people who were responsible for it were in prison. That's a pretty big statement considering what the state believes Mrs. Adelson's position is with respect to the others who've been prosecuted, convicted, and are serving sentences in the Florida Department of Corrections. I also want to say this. The defense's position in this case, from start to finish, has always been, on behalf of Mrs. Adelson, beyond respectful to the victim in this case, Danny Markell. He should not be lost in this case, and I said that in my opening statement. We presented evidence about a wonderful man he was. He did not deserve for this to happen. The Markells gave their statements at the conclusion of the verdict that was issued by the jury, and I listened to every single word. And every single word that they said came out of the terrible grief from the loss of their son and the feelings that they have developed over the course of this 11 years in prosecuting these various people and additional information that has been given to them. Every word they had every right to say. The feelings that they had are exactly what they should have. What happened to Danny Markell, as Donna Adelson has said in her statement, could not have been more horrific. He was treated like an animal, completely unaware that there was any kind of problem, that he would have any kind of physical altercation with anybody. I'm positive the furthest thing from his mind that day was that someone was going to kill him in his garage at his home. He did not deserve what he got. It's been very clear in the prior prosecutions and what was presented in Mrs. Adelson's trial about the conduct of these other individuals. They do deserve to be where they are. They do. Their conduct is unimaginable to me, that human beings would engage in that kind of conduct to bring a man, an innocent man, a well-respected man, an amazing father, to take him away from his mother, his father, his sister, most importantly, his children. That was horrific. I understand why those sentences were imposed. Not for Mr. Rivera, but for the ones that were tried and convicted. In this case, Judge, based on the evidence that was presented, the defense is going to ask on counts 2 and 3 that you sentence Mrs. Adelson to 3 years in the Florida Department of Corrections, counts 2 and 3 to run concurrently. My understanding in the court, the clerk can tell me if I'm wrong, but my understanding is Mrs. Adelson has 701 days credit time served. That's what we calculated.
I'll stipulate to 701, Your Honor.
Very well.
Anything more on counts 2 and 3, Judge? First of all, in order for it to assist Mrs. Adelson, she's going to have to be successful on count 1 on appeal. If she is, anything more than that period of time is going to basically be a death sentence for Mrs. Adelson. She is soon to be 76 years old. Her health has gotten worse while incarcerated, as anyone would probably expect. Her husband is 81 years old. Compared, 3 years compared to the man who participated in the killing getting 7 years, I believe is a just and reasonable sentence for Mrs. Adelson. We are also going to ask, Your Honor, after imposing sentence, I know it's nothing but a recommendation, but we would ask if you make a recommendation to the Florida Department of Corrections that Mrs. Adelson be placed as close to Miami as possible, where her husband resides, so that she can have visitation. I understand we don't have any control over Department of Corrections, but we would appreciate that recommendation. And may I have just one moment, please?
Go ahead.
While she's doing that, Judge, I would ask that Ms. Adelson not be housed with Ms. McBanow, or at least have a separation, if you could recommend that. I know Ms. McBanow is currently at Lowell CI.
Yes, Judge, I thank you for that, Ms. Kappelman. I wanted to raise that issue because we did check into that. Judge, I contacted the Florida Department of Corrections. They did indicate that they would be able to keep them separate, but that doesn't necessarily mean that folks who are familiar with and friendly with Mrs. McBanow wouldn't be where Mrs. Adelson would be. So we are concerned about that, about her being placed at that facility. I didn't know it before, but the reception center for the women actually keep inmates there. So I know that's a possibility, but again, that's in Ocala, and we're respectfully requesting that she be placed closer to Miami. Thank you.
Going to review the last case the defense has presented for downward departure. Ms. Kappelman, you had something else?
No, Your Honor, I don't.
Review the cases for downward departure, or in support of downward departure, the defense has argued. Having reviewed the cases presented by the defense concerning the downward departure, also as well the argument that has been presented, the court has reviewed its notes of the trial and will rule on the issue of downward departure at this point. Florida Supreme Court has a two-part test concerning whether a downward departure should be granted or could be granted by the trial court. The first is whether the trial court can impose a downward departure sentence based on a valid legal ground proven by a preponderance of the evidence. The second step is whether the trial court decides whether it should impose the downward departure based on the totality of the circumstances. As to both the non-statutory grounds that have been argued and the grounds contained within section 921.0026, subsection 2, subsection B, in reviewing the trial court's notes, what has been argued by both the defense and also as well the court's relying on the record itself, court will find that there is a ground for non-statutory downward departure, but it declines to exercise its discretion. As to the statutory ground, I will find that both the defendant was an accomplice to the offense and a relative minor participant in the criminal conduct. I will find that has not been proven, but in addition to, the court would still decline to exercise its discretion. As to the sentence in this matter, Ms. Adelson, please rise.
Here we go, here we go, here we go, here we go.
Level of planning and coordination to bring the murder of Professor Markell to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub A Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
$2,100 as a fine pursuant to section 775.083, $105 as a 5% surcharge required by section 938.04, $20 as a court cost pursuant to section 938.06, Crime Stopper Trust Fund, $3 as a court cost pursuant to section 938.01, subsection 1, Criminal Justice Trust Fund, $50 pursuant to section 938.03, Crimes Compensation Trust Fund, $225 pursuant to section 938.05, Local Government Criminal Justice Trust Fund, $2 as a court cost pursuant to section 938.15, County Criminal Justice Education, $50 as a court cost pursuant to section 775.083, subsection 2, County Crime Prevention, $65 as a court cost pursuant to section 939.185, County Additional Court Costs, and $3 as a court cost pursuant to section 938.19, Team Court Assessment.
Is there any lawful objection by the defense to these assessments?
No, Your Honor.
They will be assessed at this time. The cost of prosecution, the court will reserve jurisdiction on to determine for 60 days. If a hearing needs to take place concerning this matter, that will take place at a future time. As the defense's request for the court to make a recommendation to the Department of Corrections to place Mrs. Adelson in a facility near Miami-Dade County, I have no problem making this recommendation. The Department of Corrections will have the final say because this is an administrative matter. I will also recommend to the department that Mrs. Adelson is not to be placed in any unit or facility that would also house Catherine McBanawa. The court did previously award to the state, based on the September 17th, 2024 continuance of the trial, costs that were related to that. Ms. Kappelman, part of what you're seeking to pursue, is that included within that, or is that a separate number?
Are you speaking of the costs that were ordered in Charlie Adelson's trial?
No. The day Daniel Rashbaum withdrew from the case and the trial had to be continued.
Okay.
All costs related to moving witnesses and other matters.
Yes, sir. I don't know the answer to that, but I'll make sure that they're only in there once.
Very well. The defendant is to be fingerprinted, 30 days to appeal. Please file the appeal promptly.
Donna, may I approach the clerk? We have put I have written on the letters that I had, so we put a composite together and I've shown it to Mrs. Kaufman, who has no objection.
Please place the sticker on them so that way they can be admitted.
No objection.
We are in recess.
Daggone, he didn't read her the riot act. I was hoping he would. I was hoping he would. There she goes. Another one bites the dust. And another one gone. And another one gone. Another one bites the dust. Dun, dun, dun. Da 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 da. Na 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 na. Hey hey hey, goodbye. Get those fingerprints, Donna. Get 'em, get 'em, get 'em, girl. Give 'em, give 'em, give 'em, girl. Purple's her color, isn't it? It's what P. Lola said earlier. Oh no, really, Cherie? Has anyone checked on Berta? Ween Baby, she was the mastermind. I don't care what they say. Yeah. I think she was the mastermind and she was the puppeteer. That's what I think. And I think Charlie did what, he was told to do. That's what I think. But as far as did she pull the trigger? No. The one that pulled the trigger is in jail. And there was a whole host, okay? So Donna, the mom, she offered to fund it, right, P. Lola? Yeah. She planned it and bankrolled it, in my opinion, says Gail. A tornado for California? What in the world? Margaret, what is going on over there in your neck of the woods, ma'am? California don't have tornadoes. What in the world? What in the world? So she was like, we need to get rid of Dan. This is all in my opinion. Okay. Just my jibber jabber. She's like, we need to get rid of Dan. Do you know how to do that? To her son. And so the son, Charlie, has a girlfriend or an ex-girlfriend, and he's like, yo, do you know anybody that can off somebody for me? And she's like, yeah, I can put you in touch with somebody. And she gets another one of her ex-boyfriends to do it with one of his friends. So there's a whole host of people in the whole thing, right? And they're all in jail, except for Wendy, the daughter, who they did it for to get rid of her husband, Wendy's husband, allegedly, and in my opinion. When do you think Wendy will get charged? I don't know. I don't know. Hilarious. They list the shekels she owes, right? Good night, P. Lola. Have a great night. Oh, wait, P. Lola. Wait. Don't go nowhere yet. And I will have an awesome birthday dinner. My birthday dinner is going to be Mexican food from a local yummy Mexican restaurant. Yes. Can't wait for that.
I didn't see her.
So y'all waiting on somebody?
Yeah, George.
Barry leave.
Go out the other way.
They went out the back door.
Do
If they haven't yet, they will go out the back door.
What about the defense attorney?
The defense attorney, I've already marked this door, so they're going to come out.
the box. Where is the back door though? The court.
That's out in the hallway. I thought that was Wendy. I think they're getting ready for a maybe see if they're going to do like a press conference or something. I'll keep it on. But yeah, I always pick Mexican too, Moon Baby. It's my favorite. We're gonna get rain, but that's it so far. Oh, here comes the defense.
Do we come to Josh? Not right now. We're going to issue a press release.
Okay. Hope you feel better.
Thanks.
I'll be safe back going back.
No, we will be issuing a press release. We'll try and get that out in the next 24 hours.
Can you not tell us anything about your thoughts on what just transpired?
Unfortunately, it was not unexpected.
Thank you.
Well, duh. Of course it was not. I mean, what do you expect? Don't expect the unexpected in this case, right? I'd say she is Miss King. She's despicable.
Unless you want to like interview court TV, that's the only other people that's in the courtroom.
Oh, the white cheese sauce. Yes.
Georgia Cavalry. Or she.
I always order the same thing.
Cavalman, you said Cavalman already left.
I always order chicken fajitas and an order of the queso. Because the queso is my favorite.
Let's head over there for the moment.
I
I saw him on a meeting room, but I think it's
Those elevator dings are very annoying,
I'll go back and hear.
loud and obnoxious. I'm trying to see if they're gonna catch something, you know. Really, Ween baby? She said, "I've been waiting for you to go live. I was picked for jury duty for a civil case." Nice.
That one you can see it there.
Okay, thanks.
I'll find out hot.
Awesome. Did they ask you if you were interested in true crime? I mean, I know a civil case is different, but still, you know. You know. All right, so I haven't put the poll up yet, but I'm getting ready to put the poll up. But before I put it up, I wanted to give you some detail about the two options that I'm giving in the poll. So this week I thought that we would watch back an old trial. Since there's nothing major going on. Now, that's not to say that some awesome, not that they're awesome, but you get what I'm saying. I'll say that, an interesting trial doesn't pop up like tomorrow morning. You know how it goes, right? But let's just pretend that that's not going to happen. And we want to watch back an old trial. And there are a couple that I'm considering that I thought that you guys could pick between. And I've mentioned them before, so I wanted to explain what they were about in case you hadn't heard of either one of them, because I wanted you to vote in the poll and know what you were voting for. So I'm going to explain, then I will put the poll up and let you guys vote, all right? Long story short, some guy loaned a lady money. She had no proof of paying him back. It was a circus. Oh my gosh, a circus. I love those kinds. Makes me think of Judge Wapner. But anyway, I'm hearing a bunch of cameras snapping. I thought they were going to pan the camera. All right, so the two that I'm going to give, now don't say nothing in the chat. I'm going to tell you what they're about, and then I'm going to put the poll up and let you vote. All right. The first one that I'm thinking of is the trial of Wisconsin v. Zachariah Anderson. This happened a few years ago. Zachariah Anderson was on trial in Wisconsin for the murder of his ex-girlfriend's new boyfriend. The problem with this is the body was never found. The body of the boyfriend was never found. He was legally declared deceased, dead, because apparently the amount of blood that was found in his apartment and stuff. So there's that trial, okay? Zachariah Anderson was charged with his murder. And then the other trial is the Visine, the eye drop murder trial, where the gal, her name, and which is also in Wisconsin, and the judge in the Zachariah Anderson trial was the same judge as the Kyle Rittenhouse. Okay, he's an old man. And then in the other trial, the eye drop murder trial, the judge is my girl crush, Jennifer Darrow. Okay, same judge from the Darrell Brooks trial. Okay, so the eye drop murder trial is about this woman named Jessie Kerchevsky, who allegedly, well, she was charged with murdering her BFF with Visine eye drops. Now you're like, wait a minute, how do you... But she was like putting them in her drinks, and it was... caused her to die. And in turn, she got lots and lots and lots and lots of money. So, you guys can have your choice. Let me put the poll in the chat. I've got it ready to roll. I do have a third option, which is something else. And if you have something else as your answer, then tell me in the chat what something else would be that you would like to see. All right. So the poll is up, you guys. Let me know. Go vote, go vote, go vote. They were all yelling at each other. The lady was like, I own a Porsche and a 600,000 square foot house. I have money. Oh my God, it was nuts. Spins, no, we did not watch the iDrop murder trial. No. I mean, I've seen it. I've watched both of them, and maybe you did, but we didn't watch that together on the channel. No. I think that happened before I even started the crime channel. I've mentioned it. We've mentioned watching it several times, but we've never done it yet. So people are saying bye to each other. The elevator's still dinging. I'm waiting to see if the prosecution does some sort of a press conference or something. I mean, the camera at Law and Crime is still rolling live, so we'll see what happens. We watched the sentencing. Oh, I don't remember that. Are you not seeing the poll? Are you guys seeing the poll? Okay, they've ended the stream, it looks like. Nope, they haven't yet. Hold on. They haven't ended it yet. Oh, I see the poll. The poll's up. Maybe Cherie go out and come back in. Go out and come back in. Okay, Miss King. Thank you. Thank you, Gail. Ween Baby says, I really don't care. I haven't seen either, so what everyone else picks. Okay. Okay, good, Cherie. Good, good, good. That gal there with the long dark hair, I love her glasses. I saw her in the courtroom, and I was like, ooh, I like her glasses. Margaret, get out of here. You did not vote 12 times. I told you, you only get one vote, ma'am. Thank you, Ween Baby. Where's Sherry Jones at? Sherry Jones, where are you, ma'am? Can somebody tag her? Can I tag her in the... Hold on. Where is Sherry Jones? Oh, did you, Lindsay? I don't know, Miss King. I saw one of them in there with a phone. I don't know if they're part of the media or what. Wonder where Sherry's at. Sherry. Oh, my husband's home. Live 360 says. So, okay, they did end it. All right, then fine. Fine. Bum, 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 bum. Bum, 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 bum. Oh yay, Lindsay! I am too. I love whenever the algorithm does what it's supposed to do, right? We're a small community over here. We like it small and intimate, you know. So let's see. Oh, thank you, Ween Baby. That makes me feel so good. It also makes me sad because I've been so wishy-washy with streaming. So, Lindsay, we've been here for what? A couple years now? But we all mostly stream trials. That's what we mostly do, right? Things got crazy in the last few months, just personal stuff. And so I've not been able to stream like I normally do. And it's been a lot of hit and miss. So I feel bad for that. But I also know that you guys understand, you know, life happens. So, but just make sure you got your notification bell turned on. And I fly by the seat of my pants over here. I try to stick to a schedule, but it don't work. And the bad thing about trying to keep to a schedule with a crime channel is that things change all the time. Like hearings get canceled or rescheduled or continued, pushed back, pushed up. Trials, like I had my whole fall and winter planned on Stephen Stearns and Brian Koberger. Hold on, I have husband coming through. Hold on a minute. Yeah, I have my whole fall and winter just prepared for 2 large trials. Brian Koberger and Stephen Stearns. And then poof, nothing. Nothing. Hold on. So, anyway, yeah. So they're, you know, just poof, poof. They both went away, and now my whole true crime fall and winter has been just completely destroyed. Ween Baby, thank you. She says it's okay. I knew you'd be back. Love you. You took 17 of Margaret's votes, Morgana. I love you. Yes, Spence is right. We did watch the eye drop sentencing. I found it way back. Okay. Well, I mean, but we didn't watch the trial. I think I do remember watching the sentencing now. But I think it was at a time when I was like, you guys need to see this judge. I love this judge, you know. Lindsay, just so you know, the folks in here, they're very friendly. And Margaret tends to overdo things like vote on the poll. She lies when she says she's voted 27 times. She spills things a lot. She's always dropping things. Ooh, Mary Lou, you just sampled a DiGiorno Thanksgiving pizza on break. Was it any good? A DiGiorno Thanksgiving pizza? What did it have on it? Like gravy and mashed potatoes and turkey? I'm confused. Can I ask the ages of ladies in here? I'm 44 with degenerative body of an 85 year old from Illinois. Oh, wow. Well, I just had, today's my birthday, Lindsay. Today's my birthday, and I'm 40 something. Yeah, she does get stuck in odd places, right? And she's even been stuck under a refrigerator, Kayleen. Yes. She has. She's been stuck under a refrigerator. Lindsay, meet Margaret. There's Margaret on the screen. That's Margaret with her husband standing there eating a sandwich, wondering why his wife's laying on the floor with her hand stuck under a refrigerator. Notice the picture on the refrigerator is a picture of the Black Swan chick. What's her name? I forget what her name is. Was it Ashley? What was her name? Was it Ashley? Shoot, somebody will remind me. It's always ready, Margaret. It's at the, just the, mm. Let's see. I'm not 49 and a half, Morgana. No, ma'am. Nope. Miss King is late 50. Gail says 62. Green beans, Mary Lou. A few green beans, cranberries, few pieces of turkey, and a drizzle of gravy. That sounds disgusting. Was it any good? Oh God, I couldn't. Thank you. I am not 49 3/4. I'm not even 49. Oh, my name is Jenny, Lindsay. Jenny, yeah. That's my name. I am not. Ooh, Casey Anthony. No, that's not Casey Anthony. It's the Black Swan. The ballerina trial that was earlier was last year. I forget her name though. I can't remember her name either. Thank you, Cherie. My old eyes. Mine too. That's why I wear 2 pairs of glasses most of the time. These are my regular CNI glasses, and these are my readers. Mods Lounge you speak of. Oh, who said something about the... Oh, show Lindsay our Mods Lounge. Okay. Here, let me find it. Hold on a minute. It's under my videos. Here it is. Here's our Mods Lounge. This is the Moderators Lounge. It's so cute. Morgana and her daughter made that on the computer. I don't know what they used to do that, but it was super cute. Super cute. All the pictures in there were of the moderators on the channel. Yeah, the one that always looked like you, Mark, looked at you. The one that's on your refrigerator there. I forget her name. I think it's Ashley. Can I please get out of the fridge now? Yeah, let me... hold on a minute. Let me turn it off. I gotta find it, though. Hold on. It takes me a second. There we go. There we go. All right. So, I'm gonna go see who... Ashley Benefield? That cannot be right. Is that it? I'm thinking of Ashley Banfield. Hold on, I gotta type this in. Ashley Benefield. It is Ashley Benefield. Yep, Ashley Benefield. Ay, ay, ay. Okay, so the poll. Let me go to the poll. The poll, the poll, the poll. All right, if you haven't voted yet, you got about 5 seconds. 5, 4, 3, 2, 1. End the poll. And the winner, ding, 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 is the eye drop murder trial. So 67% voted for the eye drop murder trial, 25% voted for Zachariah Anderson, and 8% voted for something else. So it looks like we're going with the eye drop murder trial. Yeah, the one with the little girl with the hairbrush. Yeah, that's my favorite too. I like to throw that one up all the time. This one. I don't know, Lindsay. Honestly, the Summer Wells. I don't know. A case that I've been heavily invested in but don't talk about here on the channel is Sebastian Rogers. I keep up with that case, but I don't cover the case on the channel because there's too much drama surrounding it amongst other creators, and I'm not gonna do that. So, and it's kind of the same with Summer. I mean, those cases, man. But I hope and pray that they find those babies. Margaret loves Pennywise. Yeah, she does. Yes, she does. Aaron Spencer for Gail. Aaron Spencer. Hold on, I gotta look that up. Aaron Spencer. Aaron Spencer. Oh, yeah. Yeah. And you know, I've only heard about that, but I've never really dug into that one. But I'm not even gonna lie. I'd be like, good for you, Dad. You know what I'm saying? What dad wouldn't? I mean, he's running for mayor. The dad is. Margaret says, no. Did you see the Pennywise Crocs? Morgana is a massive Croc lover and Pennywise lover, so I'm wondering if she's seen them. Oh, did you? I'll have to check it out. I'll have to check that out, Gail. I didn't want to stream Donna Adelson. Like, I was against it. I did not want to. I wasn't invested in the case, but a lot of folks over here were. And so I ended up streaming the trial, and I'm glad I did, you know. Ween Baby loves horror stuff too. Morgana got a super cute pair of, what was it that you got, Morgana? Was it Nightmare Before Christmas? I can't remember. Hey, you're all the age to know about the psychic Sylvia Brown. I've never heard of her. So, okay, it was the Nightmare Before Christmas ones. Yay. Here's a hint. They're cheaper on TikTok Shop. Oh, really? Morgana, did you know that? Like how much cheaper? Like how much are they if you were to buy them online at like the Croc store or wherever you get them? A red glitter pair. No, I don't have TikTok, says Morgana. Like $10 to $15 cheaper. Wow. Harry Potter, The Little Mermaid. Obsessed with comfort hoodies and sweats. They're from Crocs. Lots of companies sell on TikTok now. Very cool. Very, very cool. Well, you guys, I got to get out of here. I got to go. I got all the papers out of Kiddo's book bag, and I need to go put stuff on the refrigerator so I don't forget things and dates and money that I have to send in and picture order form and parent-teacher conference and what else was there? Permission slip for a field trip they're going on. So I got a lot of stuff I got to go in there and hang up and write on my calendar and get ready for dinner and go hang out with the fam for a little bit. So, but tomorrow morning we'll go ahead and start with day 1 of the eye drop murder trial. And if you hang out with us tomorrow, Lindsay, I try to like speed through the trials when we watch. Like usually if it's like a current trial and we're doing like current live streaming, what I tend to do is start a little bit later in the day, like 2 or 3 hours late. That way we can fast forward through the lunch break and the sidebars and the yada yada yadas, and then still be able to end, like we catch up with them in the evening or the afternoon, right? We catch up with like in real time. And so with the older trials, you can basically squeeze an 8-hour day into 4 hours if you skip through the lunch and the breaks and the sidebars. And sometimes we even do like 1.25 speed to kind of get through it. But we'll start tomorrow morning. And I do want to start earlier tomorrow morning because I've got a shipment of stuff that's going to be coming in tomorrow for the bead stuff, and I have to get that stuff bagged up and ready for a show tomorrow afternoon. So, that's the plan, man. That's the plan, man. So, we'll start probably between 9 and 10. I would like to start early. So we'll say between 9 and 10 o'clock. Okay, and I'll make sure to schedule it early enough so that you get that 30-minute notification, like 30-minute alert notification, and we'll start day 1 of the eye drop murder trial tomorrow. I need to make the thumbnail for it and all that jazz. So, but thanks for hanging out with me today. I've missed you guys this week or last week, so I'm glad to be back today. But I will see you tomorrow. have a great rest of your Monday. And yeah, hit that thumbs up. Subscribe if you're new. All that fun stuff. All right. Love y'all, and I'll see you tomorrow. Bye.